Well, good morning. This is Bob Smith of Farm Credit East, and I want to welcome our participants to the webinar today. This webinar is sponsored by Farm Credit East Knowledge Exchange Program in cooperation with the Northeast Dairy Producers Association, that's NEDPA, and New York Farm Bureau. Also, I'd say thanks to Cornell Pro Dairy, who's also been very involved in the OSHA issue. Let me just set the stage real briefly. In discussions with Tanya Van Slyke of NEDPA and Kathy Merrill at New York Farm Bureau, we became aware of an increased interest, increased activity in inspections by OSHA in New York State, primarily focused on dairy farms, but certainly generating concerns and issues beyond dairy farms to other farms as well. Now, the focus of today's presentation is to a large extent going to be on dairy, but many of the issues are applicable to other farms as well. If we decide after today's session, which is about 90 minutes in length, that we need to do another webinar, kind of a follow-up webinar, or webinar point 2, if you will, we'll be happy to do that, and we will follow up with that and get that information out. We believe there's a lot of need to kind of focus on the issue with the understanding that we may be looking at some increased OSHA inspections, so why not provide some insights on OSHA regulations, help the participants on today's call understand what farms are covered under OSHA regulations, kind of talk a little bit about what an OSHA inspection means and any other key issues that have to be covered. We want to encourage you right now to text chat questions in throughout the presentation. If you look up in your right-hand corner, you're going to see a little orange arrow. If you press on that orange arrow, you're going to be able to type your question in below. Please do that throughout the presentation. We're going to have two presenters today, extremely impressive backgrounds, so text chat your question in as you think of them. And then at the end of the presentations, we will ask the presenters your questions. They are coming from us from Waukesha, Wisconsin today, where they've had some specific, quite a bit of experience actually, relating to OSHA and relating to OSHA inspections and audits, safety audits, et cetera, et cetera. So without further ado, let me introduce our two presenters today. Dave Shearer is coming up to us. He is owner, safety specialist with Innovative Safety Systems Incorporated, formed in 1996. He has over 30 years combined experience in safety and health. Dave has worked for 15 years in the safety field, in addition to being corporate safety director. He has over 8 years experience in workers' compensation insurance, assisting companies with injury prevention through work site audits, and supervisor and employee training. He also serves as president on the Professional Training and Development Committee for the Wisconsin Council of Safety. Also joining us today is Charles B. Palmer. He's a partner in Michael Best and Friedrich LLP out of Waukesha, Wisconsin. Chuck is office managing partner in the law firm there and is part of the firm's manufacturing and energy teams. He is a graduate of University of Wisconsin and a law degree from Marquette Law School. One of the things I noticed on Chuck's resume, he's defended employers in more than 1,000 OSHA citation cases over the past 20 years. Pretty impressive. So we have two experts coming at this issue slightly different. One from a safety audit perspective, a company that works with a lot of different firms in Wisconsin, and the other from a legal perspective. And so we have two great presenters. They are together out in Waukesha today, and we'll be kind of going back and forth with their presentation. So I'm going to turn this over to Dave and Chuck. Just want to thank you very much for being with us today and look forward to your presentation. Dave and Chuck, take it.
Thank you, Bob. So this is Chuck Palmer, and as Bob said, I'm an attorney in Wisconsin. We have offices in Wisconsin, Illinois, and Washington, D.C., and You're probably wondering, well, so why are guys from Wisconsin talking to us about this particular topic? And I'll give you a little bit of the genesis of that. The state of New York has notified the Northeast Dairy Producers Association that it intends to begin an emphasis program specifically targeted at dairy farms and larger dairy farms. And Tanya Van Slyke from that organization reached out to the Wisconsin Dairy Business Association, of which we are the legal counsel, and she did so because the emphasis program that New York is implementing is modeled after one that started here in Wisconsin. And as counsel to the Wisconsin Dairy Business Association, I got involved at the beginning of that in 2009. It started with a skid steer accident in which an individual, Hispanic worker, operating a skid steer, drove it off into a manure lagoon, was stuck and drowned. Fairly tragic accident. And that began an inspection, as generally happens when there's a fatality. There's media and so forth. And so the Department of Labor, OSHA, descended upon that particular farm up in northeast Wisconsin, began to look at the situation there and expanded that inspection into wage and hour investigators, and spent quite a bit of time and learned quite a bit about the dairy business industry. So the focus of the presentation today, I know there are some people on the webinar that are not dairy business operators. The first part of the program will talk a lot, or focus a lot on this dairy business focus, and then when I turn it over to Dave, he'll talk about some of the safety standards. So many of the things we're talking about are relevant to agriculture in general, but there will be quite a bit of a dairy emphasis because that's where New York is focusing at the present time, and we would expect that other states in the Northeast will expand into this, and throughout the country will expand into this sort of emphasis program. And it's no coincidence, if you look at the sort of first slide that we have, that this got attention. This accident in Wisconsin got attention. The slide I have is of Hilda Solis, who is the former U.S. Secretary of Labor, but was the Secretary of Labor at the time that this program was launched. And early in her tenure, her words sort of rang loudly to those who have for too long abused workers, put them in harm's way. Let me be clear, there is a new sheriff in town, and that was the attitude, you know, early on in the current administration and especially in the Department of Labor. And Hilda Solis is the daughter of West Coast immigrant farm workers, and so this accident in Wisconsin certainly got her attention and got focused upon the fact that there are a lot of immigrant workers in the dairy business model, and you know, certainly in the agricultural model today. You go back 20 years and you know, you look at the farm business, and it typically featured sort of a family, perhaps FFA students that you know, worked on the farms during the after school and weekends and summers, and most farms were not so big that they were falling up on or falling under the radar of OSHA. And of course that has changed, and this accident in Wisconsin really brought the focus in upon, you know, how big have some of these farms become, and are they subject to OSHA regulations? And we'll get to that detail in just a bit. But after Hilda Solis became the Secretary of Labor, you can kind of look at the statistics and get an idea of the way the words she stated about a new sheriff in town translated into, you know, raw numbers. So just in terms of inspection activity, this next slide shows that, well, as far as inspections or violations or citations are concerned, the numbers over the 2008 to 2012 period have actually gone down a bit. So that looks like over that 2008 period that things have gotten, not as aggressive. But the next slide sort of shows you they didn't have the increased number. They didn't have the increased capacity to inspect because they didn't have the bodies within the agency to do much more than they were doing. But when you look at this slide in terms of penalties, you get a real feel for the aggressiveness. And so what you hear a lot is that they're being more aggressive. Well, from a lawyer's perspective, from a safety consultant perspective, from an association perspective, I think we're hearing about these a lot more. There were always inspections, there were always citations, but the dollars have become much more significant. So the total penalty increased by 51%. Total repeat penalties, 75% increase. Total serious by 58%. So the penalty level has increased. So then, after this accident in 2009, the area office in Eau Claire, Wisconsin, all these names that are difficult to pronounce, Eau Claire, Wisconsin began this emphasis program. It eventually expanded throughout Wisconsin and now is being taken into New York. In Wisconsin, the focus on the dairy operations was to create a list of the consolidated animal feeding operations, CAFOs, and then do a random selection of these CAFOs within the particular area offices. And if you go on the Wisconsin Department of Natural Resources website, we actually, through sort of open records, you can see the list of exactly who's on that CAFO registration through the Department of Natural Resources. In New York, you have a similar, sort of registration process. You can't, on the website, find the exact names of the particular operations. This map shows really what's out there in the public domain in terms of the permitted CAFOs within the state of New York. The red dots show the larger facilities, and the green dots the smaller ones. And but through open records or FOIA process, you can request a list. My law partner, whose name may be familiar to some of you, is a woman by the name of Leah Ziemba, and she moved her dairy operation from your region to Wisconsin because of a family farm here in Wisconsin. She transferred her law practice from New York to Wisconsin and joined our law firm. She has pulled together a list in the past of the largest operations, and the thought is that what New York is going to do is focus on the 20 largest CAFOs in that state to start, rather than a random selection. And this, of course, raises some questions as far as, is that really a neutral selection criteria? Just because you're big, does that mean you're dangerous? Or that you should be subject to focus because you're large, when that doesn't necessarily reflect any sort of probable cause that there are potential violations or neutral selection criteria. And that's really the constitutional standard for inspection by a government agency, whether it's the police or any other law enforcement agency, is do you either have a probable cause to inspect because of concern about safety or environmental concerns, or do you have a neutral selection criteria so that OSHA in the past has been able to inspect a particular foundry because there's a complaint, or to inspect the foundry business in general because there are more accidents happening in foundries per capita than other particular industries. But then when they would develop a program targeting that particular industry, they would create a random selection so that you had an equal chance once you're in the industry of being selected for inspection, and that would pass constitutional standards of Fourth Amendment protections against unreasonable search and seizure based on a neutral selection criteria focused on that particular industry. They have announced, OSHA has announced that they are going to focus on the top 20 largest, and so right out of the gate, my question is that really going to pass constitutional protections of those 20 largest farms? And that may be a basis to say to OSHA, well, you need to go get a warrant to do an inspection of our farm because we don't believe that you have the legal standing to do that. So this is intended by New York OSHA to begin inspecting in February. And, of course, we're going to be doing more research and preparation. We really just got word of this in the last couple of weeks and pulled this PowerPoint and webinar together. And we're continuing to work on that. And my partner, Leah Ziemba, will be certainly studying the CAFO lists, probably requesting the data that the state of New York turned over to OSHA so that we can determine exactly what they're doing. One would expect, as you look at the area offices within the state of New York, and you go back to that prior slide and kind of compare those two, that you look to the western part of New York, there's quite a concentration of larger CAFOs out there, and that the area office in the yellow on this slide out toward Buffalo is going to be the likely beginning point of the targeting, given the concentration of CAFOs within their particular location. Although Syracuse probably also, since some of those kind of follow or straddle that area office, you probably see the most activity out of that particular area. Most OSHA offices have embedded within the office a compliance outreach person whose job is to teach and to educate and to reach out to the industries and give education on OSHA. And that person will probably be very busy in the next few months trying to understand and teach. They don't have inspection authority, and so it may be a good idea to sort of get to know that person, because I've found that I can sometimes get a lot of insight on what they're really doing from that outreach person. The inspectors are pretty closed-lipped, but they're all sitting around the lunch table, and you can kind of find out from the compliance outreach person what's really going on. And obviously, the Northeast Dairy Producers Association is on top of this and has been communicating with New York OSHA. We'll continue to work forward on getting more information to the dairy producers, certainly. So how is it that operators are going to know whether they may be under the microscope or magnifying glass of OSHA? Well, the first thing you should know is that within the Occupational Safety and Health Act itself, there is a prohibition against advance notice of inspection. So in very limited circumstances where you've got a remote operation in which the OSHA inspector is going to need to give advance notice because they won't be able to inspect without it, they can give advance notice. But it's actually illegal to give advance notice. So they may generally tell you the criteria that they're going to utilize for the emphasis program, but as far as when they're going to come out and who specifically they're going to inspect, they're not going to tell us that. We're going to have to evaluate that and get the best information we can as to the likelihood of inspection, but the exact timing of when a particular business is going to be targeted, we won't know that. As a result of inspecting certain locations, you can always expect that you'll have an increase in employee complaints because the word's out that OSHA is inspecting this particular industry, and then workers talk within the industry, and a disgruntled or employee or one that feels that their safety is at risk may make a complaint to OSHA because they can become aware of it. So there's sort of a piggybacking effect as well. What will happen in an inspection is that an inspection team will show up, and they'll pull out to the dairy operation, and they'll show up and knock on the door and say, I'm here from the government, I'm here to help you, show you credentials, a badge, and say, you know, you were selected as a result of an emphasis program, or they will say, we're out here based upon an employee complaint, or we got a referral from another government agency, and we're here to do an inspection, and we'd like to sit down and talk to you about that inspection. And this can make business owners sweat, in my experience. And when they started this in Wisconsin, and this last bullet point, I say, and possible wage and hour inspectors may show up as well. After the first inspection with the skid steer that I discussed, fatality, they brought out wage and hour folks, and then in subsequent inspections, they would show up in a car with maybe 2 OSHA inspectors and 2 wage and hour inspectors, somebody who spoke Spanish, certainly within the team, and it was a little bit heated because many farm operators are pretty independent people, you know, and it's my land and my house is perhaps on that land, and now you're showing up and trespassing. And while the OSHA inspectors might show up in boots and, you know, reflective vest and jeans and, you know, look like they could actually safely walk around a farm, the wage and hour inspectors would come in from Minneapolis, and they'd often be women in high heels and nylons and skirts, and they're ready to do an investigation on a dairy farm. And I actually met with the area director of the Northeast office of OSHA in Wisconsin, and I said, you know, our policy as an industry is going to be that if you show up with wage and hour inspectors who are not trained, who are coming out here not dressed appropriately, you're responsible for their safety. They should not be on a dairy farm without the experience to be there, and we will automatically demand a warrant if wage and hour folks show up along with your inspectors. And so later on in the inspection process, they stopped doing that. They stopped showing up in conjunction with wage and hour, even though OSHA and wage and hour have this sort of cooperative, collaborative compliance policy. They sort of learned from that it was creating a lot of animosity between the dairy operators and the OSHA inspectors, and that they could get a lot more cooperation in an OSHA inspection if they didn't show up with the wage and hour and double team. Now, whether that will hold true or continue in the state of New York is yet to be seen, but you know, it would certainly be something that we should be talking with the area offices in New York about, and then any other states if those occur, because coming out to a dairy operation, you know, typically is not a good idea if you don't know what you're doing, you're not wearing the proper equipment and attire. So what gives the Department of Labor the authority to do this in the first place? How can they come out to my business, my property, and tell me what I'm supposed to do or what I'm not doing right? And you know, this sentiment is certainly one that has been batted around throughout history in Congress. When OSHA first came into being in 1970, there was a lot of dialogue on the congressional floor about this topic and about agriculture coverage by OSHA. And you know, there were famous speeches given by senators and congressmen about, you know, you're telling me that that some government agent from Washington, D.C. is going to come onto a dairy farm and tell this guy whose family has had this farm for 150 years how to safely operate that farm. You know, somebody's going to get shot. This is not going to work, and you can't come out and regulate agriculture in this manner. And ultimately, through that process of the development of OSHA, there were some very limited there was some very limited authority allowed to OSHA in agriculture. So there were some really broad exceptions to OSHA's coverage for the agricultural industry, and so small family farms were essentially exempted from OSHA. But as I said at the outset of the presentation, the farm model has changed, and that's what's brought farms more under the microscope. Is a few, exceptional accidents, and then the realization that what was in the past not covered may be covered now because of size changes in the farm operation. So OSHA was limited when it came into being by Congress to only be able to regulate employers with greater than 10 employees in a farm business, or ones that had a temporary labor camp. And of course, that temporary labor camp was really focused on the Southwest, the West, where you have picking operations and temporary immigration or immigrant workers coming into do the picking operations and living in conditions of housing that might be substandard, and there was a need to sort of regulate that housing and living and safety aspects of the Southwest operations. And so temporary labor camp, if you have that, you can be covered even though you're smaller than 10 employees, or if you're greater than 10 employees, then OSHA coverage applies. In addition, the wage and hour laws were somewhat limited to the larger employers in the agricultural industry. And so the wage and hour laws, if you've got greater than 500 man days, non-family workers man days, in all quarters in the prior year, that's usually about 5 to 6 employees, then the wage and hour folks can come in and do an investigation. They have powers to subpoena wage records under the law. And they also, the wage and hour folks, can do a housing inspection if the housing is counted toward the farm agricultural minimum wage. So you have a farm operation and you provide housing and you pay individuals minimum wage or less than minimum wage, but you count $250 a month, for example, toward of their housing toward that minimum wage to bring them up to minimum wage. The Wage and Hour Division then has jurisdiction to evaluate in conjunction with OSHA whether that housing is safe. And if the housing is not meeting code requirements, then they can disallow the housing being counted toward the wage, minimum wage, and then find that you've paid below minimum wage and require back pay. So that's what was happening when it started in Wisconsin, is that the wage and hour folks would come out and evaluate minimum wage, and they would go in and look at the housing, and the OSHA inspector would be the authority to determine whether the housing was up to compliance. And then if they made a ruling that the housing, there were screens missing on the windows, there wasn't enough garbage receptacles, not everybody had a bed, not everybody had a bedroom, the bathrooms were not in proper working condition, the housing was then substandard, the OSHA inspector would issue a citation for substandard housing that's not in compliance with OSHA's temporary labor camp rules, and disallow or fine you for that. And then the wage and hour folks would piggyback onto that finding and say you didn't pay enough in minimum wage standards and you owe back pay. And that's how they were working in tandem. And by the way, of course, many of the dairy farms responded by saying, wait, I don't have a temporary labor camp. You won't let us get temporary labor visas under the immigration laws for workers, yet you're calling this a temporary labor camp. We milk all year long. We're operating all year long. How can you call it a temporary labor camp? How can one government agency say it's not and the other one say that it is? But that's exactly how they were approaching it, as saying, well, we don't care what the immigration rules are. The rule is that if this isn't the individual's permanent home, if they go back to their home, every year or so, if they've got, living quarters somewhere else in addition to this, then it's not a permanent residence, it's a temporary labor camp, and we can regulate it. So that's how they're getting authority, is that if you're large enough, if you have a temporary labor camp as they deem it to be, then both OSHA and Wage and Hour then take the position they have authority to inspect the farm. In addition, when Congress passed the OSHA Act, it also limited OSHA to certain regulatory provisions that it could apply to even larger agricultural operations. So you could be greater than 10 employees, but you're not subject to every OSHA standard that's out there, in theory. But I say in theory because on the list of standards that the Department of Labor, OSHA, is granted authority over with respect to agricultural operations, the first one is what's referred to as Section 5A1. And Section 5A1 is a section of the Occupational Safety and Health Act itself, and it's called the General Duty Clause. It's kind of a catch-all, and that law says that every employer shall maintain a safe workplace free of recognized hazards that are causing or may cause death or serious bodily injury. And so it's a catch-all. And oftentimes in industry, manufacturing, construction, if there's not a particular standard, OSHA will look to, fire codes. They'll look to National Electrical Contractors Association codes, sort of consensus standards that are out there that they can then rely upon to say you didn't meet your general duty of safety because you didn't follow this particular code. Even though it's not a law, it's a guideline, they would then pull that into a general duty clause citation. And this is where a lot of the citations that are being issued to agricultural employers are coming from, is that they will say, well, yeah, we can't regulate the electrical standards that we have for general industry, but we'll use those as a model to cite the farm for a general duty clause violation, to which I respond, well, wait a minute, aren't you just doing what Congress told you couldn't do by using standards you were told you couldn't apply to agriculture and then pushing them in through the Section 5A1 general duty clause? That is prohibited. I've handled over a dozen of these inspection citations in the last couple of years, and I've routinely, when they've had 5A1, insisted that those be dropped. We'll talk about the penalty structure and so forth, and whether it's worthwhile to litigate the case or not litigate the case, I'll talk about that in a bit. But every time I've seen one of these 5A1 citations, it's been a citation based upon a code section that OSHA really doesn't have the authority to regulate, and I've gotten most of them dropped based upon that argument. The other standard is the agricultural standards, which you'll find under the OSHA regulations. There's a whole body of regulations that you'll find under what's called 29 Code of Federal Regulations 1910, which applies to general industry. Under the construction industry, there's a code section called 29 CFR 1926, and then there's 1,000 different standards under each of those codes of federal regulations for construction for general industry. They also have logging, and they have shipyard, longshoring. So they've got a number of other standards. For agriculture, the standards, the specific standards for agriculture, fall under 29 CFR 1928, and they deal with things like, especially like power takeoff and rollover protective devices for farm field equipment. So those are really the specific standards for agriculture that are much more limited, much more narrow, much more specific to agriculture than the general industry standards and the construction industry standard. And they can cite an employer with more than 10 employees or with a temporary labor camp under those 1928 standards. And in fact, the temporary labor camp standards come in under 1910.142 or 29 CFR 1910.142. So they'll cite those standards on agriculture as well. In addition, Congress gave OSHA the authority to regulate anhydrous ammonia from the general industry standards on agricultural operations. 1910-266 logging operations. If you're doing logging on an agriculture operation, there are regulations on that, and those can be applied even though you maintain your agricultural business. Slow-moving vehicle regulations on roadways, those apply to agriculture, as well as the chemical safety standard that applies to general industry, 1910.1200. It's called the Hazard Communication Standard, and this standard says that you have to mark all your chemicals. You have to have material safety data sheets that tell workers what the hazards of the chemicals are, and you have to train workers on those hazards related to chemicals and have a policy and make sure that you manage your chemicals safely. So things like foot baths and other chemicals used on agricultural operations have to be maintained according to this standard. I'm not going to get into all the specifics, but as Dave launches into his discussion, he'll talk a lot more about what those all mean. But that's the limited scope that OSHA is supposed to be focusing upon, subject to sort of this catch-all general duty clause that we've seen OSHA expanding beyond those kind of limited regulations in some cases. So Dave's presentation will talk really specifically about the ones you have to comply with, but then he'll launch into the more common areas that OSHA is trying to pull in through the general duty clause to talk to you about what other areas you may want to be focusing in on. What are the penalties and consequences of an investigation? For a serious citation, which is defined as, the likelihood of death or serious bodily injury, and OSHA views serious as a broken bone, stitches, something more than a scratch, a contusion, abrasion. They will consider if the accident happened that the standard seeks to prevent, if it's going to be a serious injury, then they will be allowed to cite you up to $7,000 per violation. They adjust those penalties based upon the size, and so for most agricultural, even though it may be a large farm, it's probably going to be considered a small employer by comparison to the size standard. So you may get as much as a 40% reduction of the penalty. So even if it's a very serious hazard, 7,000, they may reduce that by 4,000. I'm generally seeing the citations for farm operations come in around the $3,000 to $4,000 number per serious citation. But of course, if they're citing you for hazard communication, there's 4 or 5 different areas they can cite you under that standard. So you might get five separate citations up to $3,000 or $4,000 per citation. If they're looking at rollover protective devices and the various other standards that apply, you can see citations and in the $12,000 to $15,000 range in some cases based upon these inspections. If they come in and they find that there's what's called a willful citation, where they define that as plain indifference or reckless disregard for employee safety, they may issue a willful citation, and that penalty is up to $70,000. Generally speaking, I have not seen the willfuls coming out in the dairy operations, but I mentioned, or I should mention that with respect to grain storage and confined spaces, OSHA has been willing to issue willful citations for those particularly notorious hazards. So if you've got grain storage and you've got especially teenage workers up walking down the grain, and you don't have a rescue plan, and you don't have them tied off to a lifeline and a monitor and making sure that there's not oxygen deficiency within the environment, or fumigants sprayed upon that an employee could be exposed to, they may be willing to do a willful citation in those particular cases up to $70,000. what's the liability when wage and hour folks come in? Back pay at the minimum wage. Of course, the overtime standards don't apply to agriculture, so unlike many other industries, the big dollars oftentimes are in the overtime. If you're not paying minimum wage, you're usually close to it. If they disallow the housing, yeah, that could be, some significant amount of money. My experience with these wage and hour investigations on dairy farms is that they're more of a hassle than they are a dollar penalty. Requiring you to pull together all kinds of wage and hour records is more of a paperwork burden than really any of the consequences. They've been pretty minimal in terms of any back pay that they've found. The penalty for the housing code violations from OSHA is usually greater than the back pay. So it's more of a hassle than anything when you're dealing with the wage and hour folks. The other hassle with the wage and hour, though, is that they'll oftentimes require, the standard is you've got to keep track of every hour worked. And so many farmers would say, all right, so I've got people that are, I've got immigrant workers, they're working, they live there, they have no incentive to, finish a milking any sooner than they have to because they're getting paid on an hourly basis. So you quickly decide, I'm going to pay per milking, for example. And you say, all right, whether it takes you 6 hours or 10 hours, you get paid the same. It'll probably take 6 hours in most instances because there's an incentive to do it more efficiently. And you get a premium on that, so you're being paid more than minimum wage if you do it quickly. But then OSHA comes in and says, but you're not keeping track of the hours, and that's a violation, and we can penalize you for that. And then, of course, if you don't keep track of the hours, the question's asked of the workers, well, how long does it usually take you? Well, 10 hours. So you don't have any records of that, how long that milking took. They're going to take the word of the employee, and then you end up with a wage and hour violation and back pay. And then if you don't have records, it's hard to disprove that. So you're guilty until proven innocent when you don't keep the records. So how should the dairy business operator or any agriculture operator prepare for the investigation? Well, the one comment I make is if you're really adamantly opposed to any government regulator ever being on your premises, then get below the CAFO level for registration, and you will not probably see OSHA based upon their emphasis program, or reduce your size below 10 employees, don't have on-site housing, you then can exempt yourselves from the OSHA inspections that are coming down the pipeline. Most businesses aren't going to do that, but that's one thought. Or prepare for the inspections. And you can certainly fight it. You can hire a lawyer to fight the citations, but the government has unlimited resources and you don't. And a little dig on myself, my profession, but if any of you have hired a lawyer lately, it's not cheap. So sometimes the preparation, using a guy like Dave or some other outside consultant and being ready for it is more effective, more protective of your workers, and more cost-effective than getting into the legal battle with the government. But there's certainly times when you need to stand your ground. So if you're going to prepare, certainly review housing code compliance. If you're having on-site housing, that's going to bring OSHA to bear upon you. They're going to want to look at the housing and the code compliance. Look at field equipment safety. Look at the hazard communication, and Dave will cover all these. Look at your skid steer training. They're focused on that. Do the employees get training? Do they get training in the language that they speak regularly? Do they understand how to operate these things? And then just general safety. And if you've got employees entering grain storage, this notorious accident that occurred in Illinois with 2 teen workers has really brought OSHA focus upon grain storage. And we've handled $1 million plus grain storage cases here in Wisconsin where OSHA has cited for lack of or alleged lack of confined space or grain handling standard compliance. So you need outside resources for assistance on that. Many farmers will just, the milking process workers will not do any work with the grain, and it's oftentimes family members. But if you've got sons or nephews or whatever that are working in grain, you certainly want to be safe. Obviously, some of these standards are good to protect, even though the government might not regulate the family members to protect them. How should you handle the investigation or behave? You know, the first thing you need to know is your rights, and that's why we're doing this, and that's why we'll be probably providing alerts and more information. Are you big enough to be covered? And if you look at the statistics, you know, we went through and looked at the inspections in Wisconsin, and there were a good dozen of them that OSHA showed up. The farm was a CAFO. They got randomly selected, but they didn't have enough employees, and OSHA walked away. So the first thing you want to make sure is how many employees do you have? They'll ask that question. Don't count family members. You know, how many people do you have working for you? Are you over 10? You're better off if you've got you know, one full-time person rather than two part-time people that are going to still be counted as an employee. And so you can end up being bigger because you have multiple part-time individuals rather than full-time. Were you selected randomly or due to an accident or a complaint? Why are they there in the first place? And as I mentioned at the beginning, if it's a random selection, is it really based upon neutral criteria, or are they selecting you because you're one of the 20 largest? If that's the reason they're there, you may, as I say in the third bullet point, always have a right to a federal warrant. You always have the right to say to OSHA, I'm not going to agree to an inspection without a warrant. That is your constitutional right. If you tell them you will require a warrant, they will have to leave and go to a federal judge to get a warrant, and that warrant will say that they can do the inspection. They have to complete it within 10 or 20 days, depending upon the particular judge, and they will come out and inspect on the warrant. Of course, the problem with that is that once they have a warrant, if you refuse the inspection, you can be found in contempt of court, and you can be fined as much as $1,000 a day if you then refuse to allow the inspection with the federal warrant. And you're rolling the dice a bit, because if you finally on appeal don't win your constitutional argument, you may end up having to pay those contempt penalties. So what I do a lot of times is, if the time that OSHA shows up is not convenient for me, I don't have all my resources marshaled to be able to do the inspection on the day they show up, I say, look, I can't do it today. I'm in the middle of field work. We're cutting. It's not a good time for me to do this. I'd like you to come back on Thursday. It's supposed to rain on Thursday. And the inspector will, of course, hit the ceiling. No, I'm not going to do that. I can't postpone for more than an hour. And then the answer is, well, you know, I understand that my rights are to have a warrant, and it'll take you several days to get that. So I'm not refusing the inspection. I'm simply saying that I need time to get the work done that I have, and then I'll do your inspection. But if you insist, I'll just require you to get a warrant, and then we'll see you in a couple days anyway. You do not have to provide demonstrations to OSHA. So they come out and they say, you know, I want to see how you do this. They can observe, but you do not have to demonstrate anything to them when they're there. You have a right to be present during the inspection at all times during the physical inspection. This next bullet point is sort of the opposite side of that coin. Private interviews are only allowed, but private interviews are allowed of non-management. And so OSHA has the right to privately interview employees. And so they may say, well, I want to talk to this worker, and I don't want you standing next to me. And they have a right to do private interviews, but they don't have a right to do private interviews over your right to be present during the physical inspection. So if they go over and they start talking to a worker and they're asking him to demonstrate how he, works on a particular process, that's a demonstration, that's physical inspection, and you have a right to be present. So you can say, excuse me, if you want to do private interview, it'll be quieter outside the barn. Go outside and talk to that individual, or we'll give you a space to talk to them. Be polite, be professional, but be prepared. The most successful inspections are when you know what you're doing, you've got your ducks in a row, you've got your policies, you've got your procedures, and you're prepared for them when they come in, and you seem to know what you're doing. If you're unfamiliar, if you're ignorant of your rights, you're ignorant of the standards, that's when the inspections really go badly. And so being nice but being ignorant of the requirements, those are the employers who actually get the worst citations, and the ones that are not nice that know what their rights are. So killing them with kindness won't really work. Be polite, but be prepared. So what can you expect as they sort of roll out this expansion? And this next slide kind of shows you some statistics that will give you an idea. We studied Wisconsin versus New York to see what's been happening in the past 3 years in New York in the dairy business, and I think that these statistics would be different if you're talking about nurseries or other agricultural operations, but this one focuses upon dairy. So during the 2009 to 2012 period, when they were focusing upon dairy in Wisconsin, we had 59 inspections, while at the same time New York had 9. 38 of our inspections were these planned targeted. So the emphasis program inspections resulted in 38 inspections. And of course, you didn't have the emphasis program in New York, and so you got 0 under that category. In Wisconsin, of the 59, we had 13 that were complaint or accident, and then of course the remainder were just sort of other referrals or that sort of thing. Whereas in New York, all of yours were based upon either a complaint or an accident that got OSHA out there. In Wisconsin, the farmers received 49 citations, and in New York, 7 during that same time period. And the penalties over $70,000 to the farmers in Wisconsin, $16,000 in New York. So that big 0 on the right column is probably going to look more like Wisconsin for New York, and the penalties are going to look more like Wisconsin for New York over the next few years as they ramp up this planned or targeted inspection program. So where were the citations focusing on? And this list kind of gives you an idea where to dedicate your resources. 49 citations issued. 13 of them were this general duty, and under that they were looking at animal handling, manure storage, and there you can kind of see the list, and I'll let Dave kind of talk about those particular citations going forward. So I'll turn it over to Dave.
Okay, thanks, Chuck. For what it's worth, all of this information that we're talking, some of these statistics, is available off OSHA's website. If you're not familiar with it, I would encourage you to take a look at it. A lot of valuable information in preparing for any type of inspection. It's at www.osha.gov. You can search by your industry class code. For example, a lot of this information, it's based on what's called the North American Industry Classification System, or NAICS. For the dairy farmers, it's 112120. For the forest, for the nurseries, 1114. Fruit and vegetable farmers, 11121, and so on. So you can, through that, you can research what type of citations is OSHA issuing for your industry. And this slide just shows here in Wisconsin, of the 49 citations issued, you can see we had 13 general duty violations, 21 under hazard communication. Machine guarding, 9 violations. OSHA record keeping, 4, and 2 for rollover protection. Next, I just want to touch briefly on some of the regulations. First off, just starting with machine guarding and some of the key requirements. Primary focus that we're seeing when OSHA starts the assessment, looking at the guarding on the power takeoffs. Look at any type of power transmission devices, such as chains, shafts, belts, on any piece of equipment that might be on the farm or on any of the equipment itself. As well as the fans. I'll show you an example on some of the gates, a result of one of the recent inspections. A lot of emphasis on the training and the operating instructions. The regulation specifies that all employees shall be trained at time of initial assignment, as well as annually thereafter. Also, not only and in the language that is understandable by all operators. The other things that they've questioned: no riders on the farm field equipment, and then again we've seen some citations for the rollover protection as well as seat belts. Couple examples of a citation we saw for machine guarding. On the left is just obviously an completely exposed belt. On the right, there was a guard in place, but not good enough. It didn't surround the entire belt, result in a citation. The following page, to show you how to do what we're looking at, we talk about machine guarding. It's really any type of pinch point that OSHA could be looking for. And unfortunately, this incident was the result, or the investigation was a result of fatality. The photo on the right kind of shows the overview of the area, and what we're looking at is that the cattle gate. The close-up on the left shows where the motor comes in close proximity to the beam there. And unfortunately, it was actually an outside contractor doing some work who got pinned between the gate and the post, and unfortunately was killed. Even though it was the contractor on site, it resulted in the farm also being inspected. So when we do these machine guarding assessments, we look at any and all pinch points, regardless where they are. The next couple are, and you'll look at the numbers at the top of these slides. When you see that 1910, as Chuck referenced earlier, that's from the general industry regulations. The 1928 reference the agricultural standards. These couple slides we obtained from local OSHA compliance officers, and this is some of the information that they've been providing when they're going out and educating some of the associations. So what we found interesting was in their own materials, they're referencing these regulations, even though, as Chuck alluded to earlier, Congress has said you shouldn't be doing this. So on one hand, you could say, well, we don't have to do that. We could base a legal case on that. On the other hand, from a pure safety standpoint, we can come back and say, you know, these regulations make good sense. Regardless if it's required or not by OSHA, we should have a good lockout program, as the first one states. You know, they're asking for, do you have a written lockout program? Do you have machine-specific procedures? Have you trained your people when and how to lock it out? What about who's removing the locks? What if we have a change of personnel during the process? Are we auditing the process on an annual basis? The next one, personal protective equipment. Again, it's a general industry regulation. OSHA is using the general duty clause to enforce it on the farms. In 1910-132, it says, do we go out and assess our operations? Do we have a written program? Have we looked at each and every task and then identified by task what personal protective is required while performing that task, and then have the people been trained to those standards? And again, I've listed all the standards for your own reference if you want to read more about the individual requirements. The next one, confined space. And again, from a lot of fronts, 1910-146 is the confined space regulation. 1910-172 is for grain handling operations. A lot of emphasis, again, as Chuck pointed out, from the grains operation side of things. Requirements are, have we identified all of our confined spaces? How do we keep unauthorized individuals out of those spaces? For those that are going into those spaces, that they're going into our silos and our tanks and things like that, do we have a written program? Do we have step-by-step written procedures? Are they filling out a permit before they go in there? Are we testing the air? Do we have a rescue procedure in place, as well as auditing the program on an annual basis? And just as an example, obviously the silos and such of one type of permit required confined space. So those are three of the general industry regulations that we're seeing OSHA do a considerable amount of questioning of the employees, asking the farmers, you know, do we have written policies? Have we trained to these hazards? Even though they don't directly aren't specified in the agricultural regulations, I encourage everyone to implement these programs, just like nothing else, on a pure being a safe operation. All right, next then is the manure pits and lagoons. As I said earlier, and showed you on the general duty clause violations, is how they're enforcing this one. And they're looking at it from two different fronts. We've given you some of the documentation that's out there that they're using to enforce. The two publications that we've listed here from the American Society of Agriculture and Biological Engineers, and then the National Resources Conservation Service Code 313 are the two documents that they're using to evaluate the adequacy of your protective systems around your manure pits. The first area that they're looking at is how do we prevent something like this from happening? How do we stop somebody from backing into a lagoon, possibly have a tip over or any other type of drowning, as we said earlier. So how to assess your lagoons and how are we protecting that from anybody accidentally backing into it. Quite often they're looking for some type of barrier to stop you from getting close or near the edge of the lagoon. The second area that they're looking at is just the protection of the overall area. How are we keeping unauthorized individuals? What kind of fencing do we have around the lagoon as a whole to keep unwanted individuals or untrained individuals out of that area? When we looked at some of the fatalities and accidents that have been occurring, there were a couple of those around the country where we had untrained individuals walking or working near lagoons and falling in accidentally and OSHA issuing citations. Another area that they're doing a fair amount of questioning on is the horizontal bunkers. The primary hazards that they're looking at there, the collapse, the avalanche, a lot of emphasis on fall protection. You know, anytime we're exposed to heights greater than 4 feet, we need some form of fall protection. So while we're covering or uncovering these bunkers, what are we doing to protect the workers? Do we have some type of lifeline system? Do we have a guardrail system? There are a couple options out there. What have we done for training so we don't have any struck by type accidents? And again, rollovers applies for all of our equipment. The most often cited on the farms has been the hazard communication. If we went through your operations, do we have material safety data sheets for every chemical on the farm? Are all of your containers labeled? What kind of training have you done for everybody? Not only the general training on what an MSDS is and where they're located, but also what are the hazards of the chemicals you're working with? What protective equipment should you be wearing while you're working with those chemicals? They'd like to see this all in a nice written program. And one side note to this, we've entered into it and we'll be updating the hazard communication requirements to join what's called the global harmonization system. That requires that there's going to be some changes to the labels and the MSDSs. Chemical manufacturers have 2 more years to implement their changes. From the employer's perspective, we need to have all of our employees trained in these requirements by December 1st. So it'll be a little more research there to make sure that your employees are up to date and trained on global harmonization. Next hazard that we've seen them focus is just the general electrical hazards. Some of these are the very basic. Are your extension cords in good condition? You know, do you see more black tape than orange on your cords? That's usually not a good thing. Ground plugs missing, open electrical circuits, cords that have been spliced together. You know, we maybe had some damage to a particular motor and the cord was ripped out, so we just temporarily wire it back up again. We never get back to fixing it permanently. So we want to make sure that we are fixing things in accordance with electrical codes. Next then is the animal handling. A lot of emphasis on the formal training. I've seen OSHA ask for all your training records. You know, even if it's just a 5-minute discussion with a couple of your crew members on any of these topics, I encourage those people that are doing the training to hand out a sign-out sheet. Get some documented training in this, not only who was there, but what did you talk about. Formal training, videos, whatever resources you can use to train everybody on the animal handling. The other area of animal handling, and in some of the, if you read the descriptions on the accidents that are posted on OSHA's web, they'll cite for general duty clause lack of training, or we've seen it, and the phrase that's used quite often, while herding animals, a means for a safe way out or protective barriers should be provided. You know, if you get cornered, how are you going to get out if the animals are coming at you? Do we have a safe way out? And I've seen that referenced a number of times on their investigations. So to evaluate your fencing systems, your herding operations, and are we giving people a safe way out? Next, eye washes. We've got any corrosive materials. We want eye wash stations must have 15 minutes of flow. Should be within 50-foot radius of where we're storing and using our chemicals. And then, we get focused on the animal handling and the areas, other areas of the farm as a whole, but also we do want to make sure we're doing a thorough inspection of our milking room areas. Hazards are looking for there, obviously slippery floors. We touched on electrical hazards, trip hazards, working with the chemicals, inadequate lighting that they've commented on, as well as the animal handling. Same goes for our machine shops, where we tend to find a lot of violations, unfortunately. Again, we're looking at our machine guarding in those areas, compressed gases, welding safety, cutting, grinding. We need fire extinguishers. We'll find extension cords used improperly, and just overall storage of materials, good housekeeping practices we see quite often in the machine shops. So that's just a real quick overview of some of the regulations that we're seeing OSHA search for as they're coming through and doing their inspections. So with that, we just wanted to leave a fair amount of time for some questions. Oh, I'm sorry, one last comment I want to get back to when Chuck was talking earlier about the inspection process. Just to forewarn, OSHA carries very good camera equipment. They routinely will videotape and at a minimum take still photos. I highly encourage everyone, if they're taking a picture, we would like that same picture so that we can see what evidence that they've gathered and what they focused on during the inspection. So while you're getting organized and getting ready for the inspection itself, I would encourage everybody to make sure you have a camera with you. They fully expect you. They're, in most cases, used to you taking pictures at the same time. So feel comfortable in doing that also.
Yeah, one last comment is, if you had to start somewhere tomorrow and you wanted to leave a webinar like this, and I always like people leave a webinar saying, okay, what am I going to do next? Well, the first thing I would do is I would get a hazard communication program put together, because that's the most frequently cited standard. And employers understand, and many of them in your industry have the material safety data sheets, and they think the program is the book with the sheets in it. And I tell my people about it, and then that's all I need to do. And that's the most common citation I've seen. And, we'd be happy to send you kind of a template standard. I'm a little nervous about doing that because I want to make sure people understand it and don't just take it and put their name on it and then do nothing more with it. But we'd be happy to provide that to Farm Credit or to NEDPA for you to utilize. But put that in place. Get your material safety data sheets together in a book. Train your employees on what those things say and what protective measures they need to take to protect themselves under HazCom, so that when OSHA walks in, this is oftentimes the litmus test as to whether you are, enlightened and safe, or you don't know what you're doing. Is, hey, do you have a hazard communication program? And then everything from there goes downhill if you don't. They really start digging in. If, hey, you got a HazCom program, you're really on top of things. Now, that's not to say you won't get citations in other areas, but as I mentioned before, that's about 5 citations. You don't have the program, you don't have the material safety data sheets, you don't have the training of the employees, the chemicals are not labeled, so I'm going to get multiple citations for that, and that's low-hanging fruit for OSHA, but it's easy to do and have it in order, and have employees sign off that they went through the training, because when they ask that employee, especially if they're Spanish-speaking and you don't understand what they're asking, they'll say, they'll ask a question like, have you reviewed the material safety data sheets for chemicals? And the worker will say, no, because they don't want to get in trouble. They don't, so the easiest answer is no, and they don't know what material safety data sheets mean. And by February, they're going to say, they're not even going to refer to that because they've changed the standard to this global harmonization system, so they're actually called, under this new standard, safety data sheets, not material safety data sheets. So get that program in place first, and that's all I'll say on that. But that's almost every inspection we've seen has gotten that citation.
Chuck and Dave, great presentation. We have a lot of questions that have come in. Let me note something, I guess, for the record to begin with. This is not this kind of increased focus in New York State is not instituted or not initiated by New York State. We've had a couple of clarification points to that. It's initiated by federal OSHA, and although there's probably some kind of relationship back to the New York State DOL, it's not a New York State initiative. It's a federal OSHA initiative. Okay, just with that clarification, I guess the other clarification we asked, a lot of people asked about what is a CAFO, concentrated animal feeding operation. 700 mature cows makes a large CAFO in New York. The median CAFO level was recently moved from 200 cows to 300 cows. That's under litigation, but that is 300 cows today. Okay, with that, the first question, how is family defined versus employee? For example, my nephew is working full-time and is paid. Is he family or employee?
So family will look at the son, daughter, wife, adopted child. The question is, in the nephew scenario, is the brother or sister, do they have ownership in the farm operation? So if the nephew's, the nephew is working, but the parent of that nephew is not an owner, then they will be defined as an employee.
Very good. Next question, are the 10 employees only full-timers, or does a part-time employee count as FTEs, or every employee?
Every employee, the thresholds are so low in terms of what's part-time that if they've worked, I think it's 500 hours in the prior year, then they will be considered to be a employee. So it's a fairly low threshold as far as what's the number of employees.
Is another question, is the 500 hours per quarter per farm or per company? If you have a separate company for grain operations and livestock, is that looked at as 2 or is that 1?
Yeah, we've been through that scenario actually, and in the case that I had, I was able to convince OSHA that they were separate corporations. It helped that there was some separate ownership between the two, and they only counted the employees in the milking operation for purposes of their emphasis targeting, and canceled that particular inspection based upon that. Now, I will say that they could have gone the other way on that because they kind of look at a controlled group test, and the regulations are not real clear on it, but I was able to dodge the bullet in that particular case. So, but they could go the other way is, I guess, the answer.
All right. Here's a question kind of relating back to Wisconsin and trying to determine whether it applies to New York. Do you have any overlap with your State Department of Labor with these inspections? In New York, we have a specific department within New York State DOL that deals with yearly inspections of farms for both OSHA and wage and hour concerns. Do you have anything similar to that in Wisconsin? If so, how is that program affected by the increased focus by OSHA?
Yeah, we have not had any state involvement in Wisconsin in these emphasis inspections. We do have in Wisconsin a voluntary compliance entity that is funded by federal OSHA, and so you can go out and you can get them, if you're a small, less than 250 employee business, to come out and do an audit of your programs for free, and they don't have citation authority, so they do look at the OSHA regulations and advise if you didn't fix something that they consider to be a high hazard serious citation, they can report it to OSHA. That's the only sort of state program we have, and what you're describing in New York is sounds a little bit different than what we have here as far as its regulatory emphasis as opposed to voluntary emphasis. So you might see a different sort of spin on the process in New York that we have not seen here based on what you're describing. And I could get more information from Leah Ziemba, who's pretty familiar with the processes there in New York, and we'll definitely note that and start looking into that potential, but we didn't see it here in Wisconsin.
Okay. Another question. have you seen cases where it has been harsher for farmers when inspectors return with warrants? So they must have been turned away, they had to go get a warrant. Was it harsher at that point in your judgment?
You know, that's always the fear, and that's a very good question, and always a question that's asked. And it's always difficult to determine, to look at two alternative universes. And so statistically, there's a statistic out there that says that those who demand warrants actually get more penalties. And that statistic is accurate. The question is, those who are demanding warrants, do they demand warrants because they're in deep trouble already, and so they're asking for a warrant because they got problems, and therefore they would have had higher citations anyway once the inspection went forward without the warrant? So you can't really determine based on those statistics. So then it's all anecdotal. And you know, my experience when I've been involved is that I don't demand warrants right out of the gate, and if the inspector is being unreasonable, then I negotiate, and so I usually get what I want, but I have had cases where they've had to go get warrants, and I haven't gotten a worse result than I was expecting, you know, in those situations where we've demanded warrants. But those are very unique circumstances, and it's hard for me to say because, you know, as an attorney who works with the areas in Illinois and Wisconsin and the area offices of OSHA pretty regularly, I can pick up the phone and say, here's why I'm demanding a warrant, and then we work it out and we get the result we want without them having to get a warrant. I did have a case recently where instead of a warrant, they were trying to subpoena the company's audits and the company's self-audits, and we went to federal court and we won, and the judge denied them. They denied them the audits, and the citations were sizable, but we were already, by the time I got involved, they were already all over this foundry, and they'd hammered this foundry worse in the past. So it's hard to really know what was the result of our taking the position we took. So it's just difficult to really say for sure.
Very good. Tanya Van Slyke has reminded us, and I just thought I would share this, that New York State or New York Center for Agriculture, Medicine, and Health has a training program available for hazardous communication. The training's free. It's offered in both English and Spanish, and there is a way to contact them. It's Jim Carava or Anna Myroff to set up the training. So anybody interested in NICAMP, let me give you a phone number. Grab a pen. That's area code 607-547-6084. Again, area code 607-547-6084. That's New York NICAMP, the Center for Agriculture, Medicine, and Health. Just want to add that. Next question. Can you count on architects, engineers, and others to meet OSHA standards in their design and construction? If not, who can assist with that?
I would imagine this question is really focused on design and construction of the manure lagoons and anything that might be considered to be a confined space. My experience is that architects and engineers, they look at different standards than OSHA, and I see this all the time, you know, just in general industry where there's machines that are being manufactured today that aren't compliant with OSHA, that don't have guards, made by reputable manufacturers because the engineers are not taught OSHA regulations in school. It's just a fact, and they look more at functionality and efficiency, and that's the training that is out there. And so it is still today not uncommon to see things designed that don't follow OSHA codes. So my answer to that is that I would hire a person like Dave to look at OSHA compliance on those kind of designs. You could certainly put in an agreement with a engineer or an architect that you will make this OSHA compliant. That should get their attention. You could point it out to them. They should go out and get the expertise to make sure that it is, because they're contractually obligating themselves to that. And so sometimes that will be effective if you can do that. I certainly work with a lot of ethanol plants, and they're subject to this standard called the Process Safety Management Standard that's applicable to refineries and big chemical processors. And whenever I get the chance in the development stage of those, I put in the contract for the designer that they will comply and make sure that the facility is compliant with the federal OSHA Process Safety Management Standard. And that standard requires all kinds of diagrams and process systems and safety checks, and so that contractual obligation is definitely important if you can get in on the front end of it. But I just find that a lot of things are not designed according to OSHA standards, and especially since OSHA has not been focusing upon agriculture over the years, it's going to take some time before the awareness gets there that we should be looking at that, and that we should design confined spaces in such a way that there's a place to tie off equipment that can retrieve a person from the confined space. So you get up there and you look, and I see this on a lot of co-ops, where you get up there and you look at the top of the grain bin, and there's no place to hook up equipment that can retrieve a person. And the biggest problem with confined space is that somebody's in trouble in there, and then somebody goes in to save them, and now they're in trouble, and you start stacking bodies. And so you need to have the person in the confined space tied off, but they're not building the equipment to have that facility available. And so you can look at manufacturers today and find lots of them that haven't anticipated this particular OSHA compliance requirement.
Very good. I'm going to do one more question and then turn this over to Jim Putnam, who's going to finish out today's questioning of our two experts. But we have a question coming. When determining the number of employees, our business has diversified into a store and bakery on the dairy farm. Would they count all of our employees, or just the employees that work with the cows and farm equipment? So they have a bakery and a dairy operation. All employees? Go ahead.
Yeah. So if you're not agriculture, you don't get the exemption. They cover employers with one or more employees. So we see this like you've got a cheese processing on a dairy farm. You've got trucking that you are moving your milk and you're contracting out to move others' milk. And those operations that are non-agricultural will be covered lock, stock, and barrel in full by OSHA, whether you have 10 employees or 1 employee. So the challenge there is, okay, so do I have, for my milking operation or the other agricultural aspect of it, do I have to combine the employees into and aggregate them for purposes of whether I have coverage on the agricultural operations? They can definitely regulate the bakery, the cheese processing, the trucking, the business non-agricultural aspect of it, regardless of size. Can I separate them? And then that comes down to the question of, are the separate operations common ownership, common control, integrated, separate corporate entities? And there's a multi-factor analysis, and it's, as I mentioned in one of my answers to the prior question, not entirely clear whether they can combine them or not combine them. But definitely those operations are going to be subject to OSHA regardless of size, that are non-agriculture.
Okay, Jim Putnam here, switching in for Bob. Next question, and we have a number of questions left. We are going to keep the webinar running past the scheduled time. We think they're very good questions and deserve an opportunity this morning. And we appreciate Dave and Chuck's willingness to stay on with us and work through those things. So, next question. Did I understand correctly that Department of Labor wage and hour has no authority on operations that employ less than 500 man days in each calendar quarter?
They have authority to mandate minimum wage, but they don't have that inspection authority and the subpoena authority that I mentioned. So how do they regulate the minimum wage? They reach out to the employer, or an employee comes in and reports, but in terms of going out and doing the inspection activity, that authority is not there. So so an employee makes a complaint and says, you know, here's what I'm getting paid, and I'm living in housing on a farm, and the housing is substandard, and the wage and hour folks say, well, we want to come out and we want to inspect your housing operations to determine whether they're up to code because you're counting it toward your minimum wage. They don't have that authority to inspect the housing operations where you're less than the 500 hours. So if you purely regulated wage an hour, you purely pay the person $6 an hour or $4 an hour or whatever substandard to the minimum wage, there's no housing question. They can, subpoena those records related to the wage payments, and if it's just purely you're paying less than the farm minimum wage, they can find that you owe back pay as a result of that. But the housing part of it, they don't have that inspection authority if you're that small.
I think the next one's a quick question, and rather than try to give web addresses over the webinar here, we will post this one. But next question is there a link to the standards being discussed? In other words, a website where a participant could go review those standards.
Yeah, www.osha.gov, www.osha.gov, and when you get on that main page, there'll be some toolbars and one says regulations. And you can click on that, and then it'll give you an opportunity to go into construction, go into general industry, agricultural, so you can click on those tabs and then go to those particular standards.
And we will include that in the post-meeting materials here. Thanks for that answer. Next one. So, for example, if a farm is cited for a fall hazard under the general duty clause, that would be covered under general industry standards. You have been successful in fighting.
Yeah, all the citations we've gotten so far have been small enough that we've reached a resolution. So when I define successful as fighting, they've dropped citations based on my arguments in what's called an informal conference. So there's a process. If you get a citation, you have 15 working days to go in and meet with OSHA to discuss their proposed citation and try to reach a resolution. If you cannot reach a resolution in that 15 working days, then you can contest the citation and go to court, or their version of a court, which is called the Occupational Safety and Health Review Commission. There's an administrative law judge that will hear the case and decide it, and then you have the right to appeal to the body of 3 that are appointed by the President called the Review Commission. And then if you don't like that, you have the right to a direct appeal to the Federal Court of Appeals. So far, the citations we've handled have all been so small, I should say $12,000 at the maximum, and we've knocked them down to, $3,500, and, the farm operator says, well, it's going to cost me a lot more in legal fees to go to court. So we have not seen that success in court, but we have in the informal conference negotiation process.
Okay, next question. Does OSHA or wage and hour have housing inspection jurisdiction on dairy farms when housing is not remuneration but just part of a benefit to employment?
So in that scenario where the housing is not being counted toward the wages, the wage and hour division does not have authority. OSHA still has authority to regulate, or they believe they have authority to regulate that based upon their interpretation of what's a temporary labor camp. So they say it's a temporary labor camp because the person, got another residence in, Mexico. Therefore, we have a right to regulate to make sure that that's a safe place for the person to live, and we can issue citations on that basis. I still maintain that their temporary labor camp interpretation is incorrect, and so, a farmer could go to court and argue that point, and it just hasn't happened yet because of the realities of the cost of it. So, yeah, so OSHA would assert the authority to be able to inspect it, but it wouldn't have any effect from a wage and hour standpoint.
Okay, next one, probably for Dave. What is some practical fall protection solutions for bunk silos? Very appropriate this time of the year when folks start filling them back up.
When OSHA's showed up, they've offered suggestions of traditional lanyard and harness type systems, retractable type lanyards. Of course, the argument has always been that you're going to get tangled in it. You've got multiple workers that are going to trip over it. So they seem, and I don't know where they're getting their information from, but they pretty much locked in on, well, have some type of attachment point. Maybe it's a horizontal lanyard type system, a horizontal line across there, because a couple inspections they've described this system, even though when we've asked for examples or who's using it, they can't come up with any. The other option that I've seen is just a platform and guardrail system that attaches to the forklift, so that you park that up against your leading edge, and that serves as your guardrail. Now, some of the farmers have their homemade type guardrail systems. They of course want to see some specifications that or some type of engineering specs that'll indicate that it's going to withstand minimum 200 pounds of force if you lean against and meet some of the other criteria for a guardrail system. So those are the two that we've seen. I've seen the guardrail system in use. OSHA again keeps referring to the tied off or a horizontal lifeline system. Are the two options that I'm familiar with.
Okay, back over to Chuck for a legal question. Is a warrant that they return with for the entire farm, or is it specific to only certain areas?
Yeah, so that's a good question, because first of all, it's going to start with what is the basis for the inspection. So if OSHA came out on a complaint, employee complains, for example, that the employer is not giving them information on chemicals, and so you bring into a hazard communication. The warrant would generally be written in such a way, if OSHA came in and applied for it, saying, we received a complaint relative to hazard communication of chemicals, the warrant would be written by the judge to say that OSHA has the right to do an inspection related to the chemical safety within the workplace, to question employees related to that, and to collect information related to that. If, on the other hand, they show up and they are there based upon this emphasis program, my anticipation would be that the judge would write it to say that the inspector has the right to do an inspection of the dairy operations and inspect all physical facilities related thereto, and to question employees and collect related programs, policies, and information related to the dairy operation. So then the question is, can they go out and inspect the grain facilities? Can they go out and inspect the farm fields? Can they inspect if you've got a cheese plant or trucking operation? And the answer is it's going to depend upon how the judge writes it. It's going to depend upon how OSHA applies for it. But generally, it's going to give them pretty broad authority to do the inspection related to the dairy operation. Then the problem is, though, let's say they come out and they have a limit to the dairy operation, but then the warrant will usually say, and anything in plain view. And that's generally the standard. If any law enforcement goes out on a warrant and the Drug Enforcement Agency has a right to inspect fields because there's an allegation that there's a marijuana growing operation, the warrant will say, and anything in plain view. And that law has kind of developed over time that if law enforcement is there for legal authority and they see, that inside the truck of the individual there's a vial of cocaine, that they would have a right to expand their inspection. So you get this plain view kind of, opportunity, and that's usually in the warrant. So they come out, they do the dairy, but then they see a guy driving down the road with a piece of equipment. He's not wearing a seatbelt. He's not really in the dairy operation, but now they've expanded their inspection to that. So it will be somewhat limited, but it gives this opportunity to do this plain view inspection as well. But yeah, I mean, it should be limited to the dairy operation because that's the basis of the emphasis program. And if it's a complaint, it should be limited to the specifics of the complaint.
Okay, next question. Outside of New York State Center for Agriculture, Medicine, and Health, who is limited in personnel, what are the options for outside help for direction in getting our farm up to snuff for this?
Each of the states has a voluntary compliance program, OSHA consulting. So when there's a federal OSHA, which is what you're dealing with in New York, the state will have a component that's provided and paid for and budgeted by the federal OSHA, and that state agency, which I can send you the kind of link for that agency, can come out and do consulting for certain size businesses. As I said, in Wisconsin it's 250, and I'm not sure what the limit is. Probably similar in New York, less than 250 employees. They'll come out and give you OSHA-specific training, and that may be the better free entity because they will know the stuff much clearer than the agricultural organization with the state that you're mentioning. Then what happened in Wisconsin, and I'm certain that you'll probably see this sort of thing in New York, is that the technical schools, especially in the more agricultural areas, if you're training farmers or training agricultural employees in those technical schools, they will want to jump on and start doing some training related to that and outreach. So you may see a proliferation of other resources, or they'll work in conjunction, or they'll apply for a grant from OSHA for funding to be able to go out and do some training. So some of that stuff is probably yet to be developed. And then, of course, there's always paid consultants like a guy like Dave that can come out and do a training. It may be efficient for operators, especially those 20 largest, to say, okay, let's band together and let's engage a trainer or somehow marshal our resources so that we're getting some efficiencies or economies of scale, where they'll do several trainings throughout a week period, go from one farm to the next. I think that's something that working together with your association, you might be able to sort of manage resources more effectively, and that's somewhat what we did here in Wisconsin, where we worked with the technical colleges and the outreach personnel from OSHA. Those outreach personnel will not come in and do an individual operator training, they're prohibited from doing that. But if you get 2 or more businesses together, they will come out and do a seminar presentation. They won't generally do the employee training, but they will come out and train the management, train the trainers or the owners, who can then take that information back and do the training of their employees. So that's another option, is to use the state, or do you use the federal outreach people from the particular OSHA office. And then you have some credibility with OSHA when they show up.
To that response from Tanya Van Slyke at NEDPA, she says, we have a contact at OSHA. That compliance educational individual is currently putting a presentation together. We will be working with him to offer trainings across the state. However, he cannot go to farms. So that's just a add-on to that particular answer. Next question, I think it's relatively straightforward. What size tractor needs a rollover protection system?
Boy, I looked at this, and I don't remember seeing any limits on it, but I did see OSHA cite one that was a pretty small tractor. I mean, they had taken off the rollover protective device so that they could drive it into a small doorway, and they couldn't get in there without taking it off, and then OSHA saw it and cited it, and it was a pretty small piece of equipment. So I didn't really look at, I didn't see anything in the regulations that said that there was a lower threshold. Dave, do you know?
Yeah, it does describe in the ROPS regulation, under certain conditions, if it's going to create greater damage. Let's say if you're, for picking crops or something like that, that the ROPS is going to create a hazard to your to the crop and such. It does allow it under certain circumstances, but it also lists other protocol that you have to in place, such as training and so on and so forth. So we can forward you that exact verbiage that's in the regulation that says under these criteria it is acceptable to operate without a ROPS, but these are the other provisions you must make then.
But nothing minimum as far as...
No, not size-wise, no.
I've not seen that. Yeah, I've just not seen it on in their standards.
Okay, moving along. Next question. Does OSHA give you time to make a correction before the fine is levied?
If they see it, they must cite it. So if they come out, you may get a credit. They give you credit like 10% reduction for good faith if you do a quick fix. If you fix it right there, that'll reduce the penalty a slight amount, but it's not going to prevent the citation from being issued. And the reason they do that is they want to have the citation on your record so that if they find it again, they can do the repeat citation and ramp up their penalty enforcement. So, do it once, the citation may be a couple $1,000s, and you may be able to settle it for $1,000. Do it twice, you start to move towards $70,000, and so they'll cite that first time.
If I could go back and correct that, on the size of the tractor, the regulation refers to a low-profile tractor, and look at the definition of the low profile. It talks about less than 60 inches, and the clearance from the bottom of the tractor chassis to the ground does not exceed 18 inches.
Then they don't have to have rollover?
Then they don't have to have the ROPS for those activities.
Okay. Thanks, Dave.
Okay. Next one, if there is a complaint, are we entitled to know where the complaint came from?
No, but you are entitled to get a copy of it. And the way you handle that is you say, well, I'd like to have a copy of the complaint. I understand that you can't identify who made the complaint. However, you can block out the name, and I'd like a copy of the complaint, and you have a right to insist upon that. But they don't want to give you the name because they have whistleblower standards that they're very careful about disclosing the identity of the individual for fear of retaliation.
Next question, is there a specific amount of safety training required per year?
It's not expressed in a quantity like you'd have a continuing education type of standard for licensure. Instead, they have a number of regulations that require, training. So forklift operations, you have to recertify forklift operators every 3 years, but they don't specify the number of hours. For lockout, tagout, which of course is a standard that we would argue doesn't even apply to agriculture, but they might bring it in through the general duty clause. It requires annual auditing of your lockout procedures. So if you're going to do maintenance on a particular type of machinery, each year you need to go out and watch the people doing that maintenance and make sure that they're still following the procedures. So that's an annual, but it doesn't have a quantity attached to it. Dave?
Yeah, many of the regulations just require that the employees be able to demonstrate proficiency. And OSHA will, during their interviews, ask various questions regarding their knowledge of the regulations and the requirements. So it's more, the focus is more so on the quality of the training and the knowledge of the individuals versus the quantity of training.
But Dave, didn't you, in looking at 1928, see that the farm field equipment requirement was a yearly?
Right.
Yeah.
Annual requirements just does not say the length of the training or.
So there's an annual requirement for safety on farm field equipment, but it doesn't say the quantity, but annually.
Next question, what are the exemptions for fewer than 10 employees?
So if you're less than 10 employees, then OSHA cannot regulate their standards on your farm. That means they can't apply the hazard communication standard. That means they can't apply the agricultural standards. You are exempt from OSHA if you're less than 10 employees and you are agricultural. That doesn't mean, if you got, again, as I said, if you got a bakery or cheese operation or trucking, then that exemption doesn't apply. The 10-employee exemption does not apply to non-agricultural.
I think the next question you kind of covered before, but I'm going to put it out there, and if there's any, if it really is a different question, then please answer it in depth, but otherwise you might just observe, kind of reinforce what you said before. It goes as follows. If providing housing but not counting it towards minimum wage requirement, does OSHA or Department of Labor have any inspection authority?
Yeah, OSHA does, wage and hour does not.
Okay. Are rented apartments off the farm for workers considered to be a temporary labor camp?
No. So if you had an apartment building that was right next door, so you bought a separate parcel of land, and so the intent really was that I needed the guys to be able to roll out of the bunk and make the operation work, and they're right there next door, then they could say there's a nexus between the housing and the farm. But you got a farm out in the countryside and town is 3 miles in and they got an apartment and you provide that housing to them, but it's remote from the farm. It is not going to be considered to be temporary labor camp. So it's a connection to the farm, the convenience for the employer that they don't have to have transportation to get there. They won't treat that as a temporary labor camp.
If a farm has less than 10 employees, but some are Hispanic, for which they provide housing, would that farm be targeted?
If that housing is there at the farm, yes.
Okay, next question. You mentioned under wage and hour standards, they say you are required to keep track of every hour worked. How does this apply to salaried employees?
So for salaried employees, assuming that they are, under the Fair Labor Standards Act, which is the regulation that applies to most businesses, you've got what's called exempt and non-exempt employees. Exempt employees are those who meet certain criteria. They're executives, they're professionals, they manage, 2 or more other workers, and they meet certain minimum. And so the law doesn't recognize the concept of salaried versus hourly so much as it recognizes exempt versus non-exempt. If you're exempt from the Fair Labor Standards Act, then you can pay a person a salary and you don't have to pay them overtime because they are exempt. So assuming you've got an exempt employee, then the federal law does not require you to keep track of their hours because they're exempt from that Fair Labor Standards Act. You do have to keep track of the hours of the non-exempt employees. And some employers will pay a non-exempt employee on a salary basis either because they've just mistakenly considered them to be exempt or because they do it on a salary basis just to give them more, feeling that they're important or whatever, but they still have the obligation to pay overtime if they work over 40 hours. In those cases where they're not exempt, even though you say they're salaried, you have to keep track of their hours. And then some states, like our state, requires you to keep track of all hours, even of the salaried employees. And so, what we generally do is we'll have people sign in and sign out, or you keep track if they're using a computer as to when they log in and log out, just to comply with those regulations. The states that do that really, I have not seen them really do any kind of regulation of that if the person's truly an exempt employee. But the problems come in where you call somebody salaried and you're wrong about their exemption status. I hope that makes sense to you, but that's where all the litigation is the people that are considered to be exempt, and then they're paid on a salary basis and they work more than 40 hours and then they have overtime. But if they're truly working in the agricultural industry, you don't have overtime requirements anyway. So you just have to pay them for all hours worked. And so if you're wrong about their status and they are really non-exempt employees because of the work that they do, and you don't keep track of their hours, then you're sort of at their mercy of them saying they work 10 hours when you think they worked 6. And then a lot of times the government will reward them back pay based on what they said, and then you have the obligation to try to disprove it.
Next question, please explain the New York Department of Labor consultation program which helps in preparation for an OSHA inspection.
Yeah, so the consultation program, which I'll locate and send that link out to you guys, you got to contact them. They usually have a backlog. They will probably, in your case, have to get educated on the specific agricultural standards because they haven't been doing it. Maybe you're lucky and you've got somebody that actually has some knowledge or grew up on a farm or has done some consultation with a farm already within that organization. They will then actually physically come out on site, unlike what we just heard the OSHA, the federal OSHA compliance assistance people won't come on the farms. The New York State group would actually come out there and look at the site and look at your operation, look at the milking operation, look at your HAZCOM program, and can evaluate it and determine whether it's compliant or not compliant. And we just kind of got on this in the last 2 weeks. I've not reached out to that organization yet to find out how long a backlog they have or what their experience is in providing that training. We will do that and provide that information to Bob and Tanya.
Next one, we have a farm with multiple locations, heifer facilities on our CAFO plan, but we milk all cows at one location. Do inspectors have a right to see all locations?
So the heifer location is separate from the milking, but it's
They're satellite locations, correct?
Related to the dairy operation. They might try to assert that authority, and I don't know what a judge would do with that. I think I would take the position, first of all, I just wouldn't even mention it, and if they took the position that they want to inspect it, I'd say, look, I'll consent to your inspection of the milking operations, but I will not consent to you expanding to that other part of our business. If you're interchanging employees between the two locations, however, I think you're going to end up being stuck with, well, you know, if they're working here and working there, it's all one operation. So if you get an interchange of employees, you probably end up, if they go, you demand that they get a warrant, they're probably going to get a warrant to be able to look at that too.
If a cab tractor does not have working air conditioning, is it considered a hazard?
we see this all the time in construction where a guy will complain it's hot, and you know, actually I just had that yesterday or day before when it was 96 degrees here. The answer to that is that OSHA usually enforces the heat exhaustion scenarios under their general duty clause. If you don't have AC, it's broken or whatever, you can substitute by providing lots of cool water, telling people to take breaks when necessary, teaching them to identify the signs of heat exhaustion. So OSHA has a sort of guideline on combating heat exhaustion. You could use those protocols in lieu of air conditioning if you wanted to be, you know, you wanted to avoid the potential that OSHA could come in on a general duty clause and say, you know, you're exposing people to heat exhaustion. But there's no standard that says you got to have AC in your tractors. Welcome to the good old days.
Sounds like you better fix the AC. If an owner isn't present or out of town, will they, and I presume the OSHA inspectors, come back?
Yeah, and you know, you find this all the time, even in general industry where the safety person's off that week or the manager. If they show up and they find somebody who appears to be in charge, and so you've got a foreman, and they say, well, let me talk to the person in charge here, and so the owner's not there, and the foreman comes up and starts speaking to him, and they say, can I inspect? And the foreman says, yes, you've consented, he appears to be in charge, that inspection will be legitimate. If you're not there and you say to them, look, I need to be there, I don't want you to inspect, and you refuse the inspection, they will generally come back, but they're going to give you a flack about it and say, well, I should be able to inspect within an hour, I want to go in and inspect, etc. And that's when you play that sort of, well, look, I need to be present, I can require a warrant, I'm not demanding that unless you make me demand that, I simply need to be there, I'll be back tomorrow, let's meet then. And you usually can get what you want if you're persuasive enough about it, and I've had lots of times where clients have called me and said they're insisting to inspect, and then I just pick up the phone and call the area director and say, look, we can go the legal process route or you can come back tomorrow.
In farm labor housing, what do they look for in the way of violations? And I suspect this could be a long list, but maybe if you'd hit some highlights.
Yeah, so the highlights are screens on windows. If you don't have AC and they got the windows open and you got flies coming in, they're looking for cockroaches. And you know, the fact is that if you've got immigrant workers, you've got cockroaches because, you know, in many cases they're used to living that. They go home, they bring the suitcase back, and then you've got the bugs, and so you need to be spraying. A lot of farmers are like, I don't want to invade their privacy, and I'm the boss, and I don't want to go into their housing. That's their private domain. You don't go in and look, and so they've got bugs. Nobody ever says anything about it. So you go into the kitchen and you lift up a pan, and there's the bugs running around or whatever. That gets OSHA and the wage and hour people all bent out of shape. It's the bugs. You don't have a bed for each worker. They don't have a bedroom. You know, they're out in the living room on a bed. They don't. You know, you got to have a bed and a bedroom for. It does, I mean, they can share a bedroom, but it's got to be a separate, you know, room in than the main living quarters or, you know, family room, living room sort of scenario. Garbage overflowing, not enough garbage receptacles, and drainage of the sinks. Those have been the ones that I've seen most frequently focused in upon is drainage, pest control, garbage, beds, and a place to sleep. You know, if you don't have enough lighting, and screens, I mentioned that too. And if you don't have enough lighting, you know, light bulbs burned out and you're not providing lighting, that's also one.
I I've got a text here, and I think I'll try to get it right, but Jim Caraba, who I think is with the New York State Center for Agricultural Safety, says that they are happy to help farms prepare for these inspections, and we'll put their contact information up on the site as well, but they've obviously got a website and an 800 number, so another source of assistance to you. I'm going to move to the next one. If structures are built to NRCS standards, can we assume that they are OSHA compliant as well?
You know, as built, well, yeah, I don't know the answer to that. Sorry, I'm not familiar with it. Dave, are you?
No.
Yeah.
Okay.
Sorry, you stumped the experts. Good job. Do we have a reward for them?
What is it, a T-shirt or an iPad or whatever? Let's keep rolling here. I think we're winding down, although we're still getting questions in too. So, again, Dave and Chuck, it's now 12:30. You ready? Are you okay with we keep going a little bit here, or do you want to wind it up?
Sure. It's not lunchtime for us yet.
Okay, we're good here on the East Coast then. Have you seen these OSHA audits coincide with other federal audits like I-9?
You know, the immigration, OSHA has been very deliberate at not bringing the immigration aspects into any of the inspections I have handled. They have, in fact, internally decided that especially under Hilda Solis, that they're not going to do anything to, you know, raise the specter of harm to the employees. So, you know, they bring in immigration, the I-9s are looked at, one's disallowed. You know, you got to check, you got to investigate this particular worker and determine whether this is really valid, and then there ends up becoming a sort of a whistleblower kind of thing because the employee is losing his job or being asked questions by the employer. So they've been very deliberate about not doing that. And I think that probably makes some sense from their perspective as far as not wanting to create a potential for the appearance of retaliation against the workers, so then the workers don't want to communicate or cooperate with them. But I'll tell you that the fact is that a lot of the workers in these scenarios are very nervous because, hey, it's a government agent, and I don't know whether they're immigration or whether they're, you know, I don't know what Department of Labor it is versus immigration. I don't want to talk to them, and they, you know, they're very close-lipped about it, and they'll, you know, every question that's answered is no. You know, and I alluded to that one. Well, you know, have you seen the material safety data sheets? No. Every answer is no, and you know, you have to be really proactive to protect yourself in these inspections that the employees are giving no answers when the answer should be yes. But yeah, I don't see the immigration aspect coming into it. I also have not seen any referrals to the environmental folks by OSHA. Just wage and hour and OSHA joining in. Now, you had that one fatality with the electrical. Did they bring any housing or any building code folks in?
No, just OSHA.
Yeah, so it's really just been Department of Labor. You know, within Department of Labor, OSHA. I haven't even seen a National Labor Relations Board combined scenario where they, you know, so that in theory, if employees are engaged in concerted activity where they're complaining about safety together, the National Labor Relations Board could intervene even though there's not a union involved. But I've not even seen referrals over to the National Labor Relations Board in any of these cases, just wage and hour and OSHA.
Are we responsible for hired contractors' OSHA compliance?
Well, Dave mentioned the fatality involving the contractor that was working on the farm gate, and it certainly created some problems to the farm because he got killed while working there, and then that expanded to an OSHA inspection. Was the farm cited for the electrical contractor exposure?
They were cited for the machine guarding or lack of machine guarding, which caused the fatality.
Yeah.
So indirectly, yes.
Yeah. And then responsibility is sort of a loaded term, because if you have a temporary worker on site, workers' comp is the exclusive remedy for like a temporary help agency employee or for your own workers. But if somebody comes onto your site that is not your employee and they're killed or injured, they could potentially sue you for personal injury or wrongful death, and you could be held responsible in that way for the exposure of those particular workers. So, you know, there's certainly liability there, and OSHA can end up citing you for the exposure. The way OSHA handles that scenario is they have this thing called a multi-employer worksite policy, where, and this has been upheld through federal court in the last couple of years, where they can cite, and if you're an employer, meaning you have employees under your employment, you're covered by OSHA. Your own employee does not have to be exposed for OSHA to cite you. They can cite you if you're the controlling employer, so you control the workplace, even though the exposure is to somebody else's employees. If you created the hazard, if your own employees are exposed, or you're responsible to contract to correct any discovered violations. So those 4 categories they can cite you for, even though your employees are not exposed. So yes, from an OSHA standpoint, they would hold you responsible for exposures to outside contractors. But again, then that gets into the question of, well, I'm an agricultural employer. Can you hold me responsible and cite me under standards that don't actually apply to me? You know, and then they have to try to use the general duty clause against you in that scenario. And you know, you've got a legal argument. And you know, certainly if there's a fatality like that in Dave's scenario with the electrical contractor, you would not want to accept that OSHA citation, because it will become evidence in the personal injury claim that's going to follow that you violated a standard, and that's why the guy got killed. And then it becomes easier for the personal injury claim to rack up big dollars. So that would be a case where you probably would want to go to court to challenge OSHA's authority to regulate the lockout tagout standard, for example, because it doesn't apply to agriculture.
Next question, and I think it goes back to a previous one, and so I'd ask you to just kind of add on to your previous answer, and it goes as follows. If a farmer has several locations that would qualify as large CAFOs, are the inspections limited by each location, or does ownership of multiple CAFO locations trigger inspections at all locations?
Yeah, that's a good question, and it's yet to be determined. And the reason I say that is because, you know, I don't think OSHA has yet even, OSHA in New York has even yet determined their exact criteria for selection. My suspicion is that, it will be a location, and it will follow whatever your permitting application process was for with the resource conservation. What's your department? Your equivalent of our DNR? I've forgotten off the top of my head. But the folks you have to register for your manure facilities, however you're registering that is going to be the list that they work off of. And so if those separate locations are registered separately or applications are filed separately, that they're going to treat those as separate entities for purposes of the targeting. But there's no law on this. I mean, they're using this as a mechanism to find their targets, but there's no regulation that says here's how you're supposed to do that. That's why this is a little bit suspect as to whether there's really a neutral selection criteria if they don't take that list and do a random sort of selection process and in fact just say, well, we're going to hit the 20 largest. So a lot of questions should be asked when they first get out there as to how did I get on this particular list. And I suspect that the particular inspector will say, I don't know, I was just told to come and inspect. And then we may need to have some dialogue with the particular area office. I mean, if they're really just targeting you based on your size, as opposed to being randomly selected, you're going to have to make a decision whether you want to demand a warrant and make them go through the legal process to prove to a judge that you were properly selected.
Okay, I'm going to do the last question here. We'll kind of go to a brief wrap-up and call it a day here. I think this last question is something that we haven't quite delved into yet, but it goes as follows. Our farm has an incorporated entity which owns the real estate, facilities, and equipment. This entity employs 6 employees. We also have an LLC, which leases the facilities and is the dairy operation. This LLC employs 15. Is the incorporated entity exempt, and I presume it means from OSHA? This is a common business structure here in the Northeast, folks. So, very commonly, we have a lot of dairies and other farms that are structured in that manner. So it's not a one-hit question.
Yeah. So that and that's common here too, and we had these exact scenarios. In the cases that I handled, we were able to keep OSHA out of the incorporated real estate. And that operation generally did the farm field work, and the employees were oftentimes family members with a few non-family members, a nephew that the uncle didn't have ownership, or the father of the nephew didn't have ownership, and so we were struggling through that. Okay, well, what if OSHA wants to go into the safety and as far as the grain storage facilities, the fields, etc., and they never went there. They only limited themselves to the dairy, the milking, the LLC operation, as you described it, with the 15 employees, and so they never pushed the limit to get into the real estate entity. We were prepared to take the position, and in one case actually ended up taking the position that that's a separate, not part of your emphasis program, and they backed off. Can I say that when push came to shove, they might not get a judge to expand it, especially if they saw something in plain view, that they were concerned about a hazard? They might get a warrant on that, and then you'd have a choice to make at that point of saying, well, I'm not going to allow you to inspect even with the warrant, because, and then you'd have to go to court and bring a motion to what's called quash the warrant, saying we're 6 employees in that operation, it's agriculture, OSHA doesn't have jurisdiction to inspect it, we weren't selected on neutral criteria, and you'd challenge all those things. We just never had to get to that point yet, where that was tested. So, but there are arguments against that, and so far OSHA has, in the one case where I had to make the arguments, they backed off, and in the other case they've just not even gone there.
Okay, I'm going to reserve the right for me to ask 2 kind of wrap-up questions to our 2 speakers. I realize we haven't gone through all of them, but I think we've gotten through most of them. We've certainly given everybody that's hung in there with us an opportunity to have at least one and usually several questions answered. So I think in fairness to everybody, we will wrap this up. So first, the kind of the commercial announcement. A number of you have asked, will you be able to access this material after we close out of this session? And the answer is yes. We will post a recording of the session, and that will have the PowerPoint and so forth. We've been busy taking notes here. Looks like there are some helpful resources to you in New York State Center for Agricultural Health and Safety, and they've given us a number of suggestions. We'll make sure we get those incorporated here. So the material will be on the Farm Credit East website. I suspect our partnering organizations here, New York Farm Bureau and Northeast Dairy Producers, NEDPA, will provide links or otherwise connect back to our material. So if you want to go back through it, it'll be there. If you want to recommend it to friends in the industry, we certainly would appreciate that. The goal here is to provide this to everybody who needs it. So before I ask the follow-up questions, I want to really compliment and thank Dave and Chuck here. I think your answers have been very practical on a very emotional and difficult topic for all of us. I know it. A lot of this just makes you angry and makes you feel overwhelmed, and so you've done a very nice job that way. And I really appreciate how you've handled the Q&A, both accommodating us way past the deadline, but very thoughtful. Again, practical answers, and the one that you didn't know, you said we don't know, and that's always a good sign with the experts when they fess up and they don't know. So I appreciate that. Dave, I'm going to give you this as a wrap-up question. You can say whatever else you want, maybe a brief commercial for yourself or whatever. But so I think if I'm a producer on this phone call today, I'm feeling a little overwhelmed at this point. Geez, there's all these different issues, and you hope it'll never happen. But as a good manager, you want to take steps to make sure that if it does, you're well positioned. One, practical first step when you get done with this phone call and you go have lunch and you get back to work. What's one practical first step that you would advise producers to take after this webinar?
Well, I think it's just a matter of kind of prioritizing, based on what your current program, what you have in place. And like Chuck said earlier, and I can't agree more, is the hazard communication is the first area that they're focusing on. So, to get some of those fundamentals in place, but then to start prioritizing, whether it be, what OSHA and what's in the agricultural regs, or just looking at bigger picture. Where we're seeing our big injuries, and when you read some of the accidents, a lot of severe injuries around manure pits, machine guarding are two of and the equipment operations. So just to kind of clear the head a little bit and evaluate your own program and start prioritizing, and then not trying to do too much at one time. And it can be overwhelming. There's a lot here that we threw a lot at you today, but just to have some realistic goals of what can we do in what amount of time, set some target dates, get more people involved, get others, get your foremen and such involved to help with some of this, and it can be done. I know we've got a kind of a February deadline hanging out there from the Emphasis program. We can get a lot done between now and then.
So Dave, thank you so much for your participation today. You've done a great job with us, and again, we really appreciate your both your practical knowledge and how you've expressed yourself, and willingness to hang in there with a lot of questions. So, Chuck, my question to you is going to be a little bit different. I think you covered this early on in your comments, but I think it's worth going back. In a younger part of my life, I had a little experience with unannounced visits from business inspectors, in my case, the local health inspector. And I think it's fair to say when you're confronted with that issue, your system goes into fight or flight. I think that's natural human reaction to this experience. So should any of the participants here have that experience, if you would kind of give us the brief summary of you're confronted with the unannounced inspection, what's your advice?
Yeah, my advice is to have a sense of humor. That always goes a long way, and these inspectors are human beings, and so they can get very defensive if you get defensive, and so reacting in a professional manner of saying, hey, how's your day going? Where are you driving in from today? And just kind of some chit-chat at the beginning to sort of break the ice and, get to know who that person is and, so forth, can go a long way rather than just kind of blasting off right away with what the hell are you doing on my property and get out. Because you're going to need that rapport as you kind of move forward. These inspectors will tell you more the more you sort of develop that beginning sort of relationship with them. And I'm not saying you have to be friends, and I'm not saying you even have to be nice, depending upon how they're handling things, but just kind of break the ice a little bit and get to know it. Then from there, really try to find out how many have they ever worked on a farm? Did they grow up on a farm? What experience do they have? Because some of these inspectors don't know a newborn calf from a 3-month-old. They're just neophytes, and so you have to assume they know nothing at that point and start from that perspective. So knowing what they know is very important, so you can know what kind of language you need to use. And even in this webinar, we referred to CAFOs, and there was a question as to what that was, and of course we assume, because of our experience, that you'll know that, and other people on the line will know that, and you just never know what people know until you find that out. So get a level of that experience. But more importantly, I would say right now, you want to know whether you're the target of OSHA and whether you're part of their emphasis. If in fact New York OSHA is going to be focusing on the top 20 in size, are you one of them? Or are you not? Or are they going to do a random selection? So working with your association, which, kudos to Tanya and Bob for really getting out ahead of this thing and immediately putting this dialogue out. I'm confident that they're going to be on top of what OSHA is doing and who's going to be a target, so that you can know that I am in the line of sight, or I fall right at the border of it, or I shouldn't even be inspected. Now, that's not to say you shouldn't try to do some of these things that we're identifying, but knowing when they walk in what your position is going to be. I'm not being inspected under lawful process. I'm going to require a warrant. Or I am targeted properly, and so I'm not going to require a warrant. Or I think I'm not being targeted properly, but I'm not going to demand a warrant because I'm going to be able to convince them that I'm compliant. So that's my perspective, is kind of having a, start thinking from the moment we hang up here, which way am I going on this? And then getting more information so you're ready to make that decision, and then still approach it, not right out of the gate, get off my property, go get a warrant, because the next thing you're going to do once you do that is you're going to pick up the phone and call me, or you're going to call a lawyer there, and you're going to say, I just threw OSHA off my property, should I have done that? And then, the next question that the lawyer is going to ask is, well, tell me some more about the person that was inspecting. What did they tell you? What did they say? What did they give you? And you've lost that opportunity to get that information. So still do the chit-chat, even if your plan is to throw them off the property. Get as much information as you can before you do that.
So Chuck, I'm going to summarize. I think you're telling us all, take a deep breath and see if you can establish a working dialogue with the inspector and go from there. So I really appreciate that. Again, nice job to both of our presenters. Great questions from those participating today. We've never had this many questions on one of our webinars. Sometimes it's like pulling teeth to get good questions, and obviously you've been very engaged. Again, I realize I've skipped over a handful of questions here, but tried to give everybody an opportunity. There will be additional information. Again, want to repeat the thank you to our partners on this webinar at New York Farm Bureau and the NEDCO organization. We work together with them on a number of things, and always appreciate the good working relationship with those organizations. With that, Chuck and Dave, I think it's lunchtime in Badgerland. Even. So, again, thanks. We are adjourned.
All right.